very special Stowe Talks X Smart Divorce collab podcast. And a bit of a new venture for us as we're joined by an old friend of the podcast, Tamsin Caine from Smart Divorce. I'm Matthew Taylor, partner at Stowe Family Law. And today I'm joined for our special episode with Tamsin and Rhiannon Gogh, a special educational needs and disability financial planner. Rhiannon is the director of PlanIt Future and founder of SENDA, the UK Alliance of Special Educational Needs and Disability Advisors. So Tamsin, welcome back. Rhiannon, welcome to Stowe Talks. We're going to have a fantastic discussion today about all things SEND and divorce. But if we can start by introducing yourself. So Tamsin, if you can reintroduce yourself to our listeners, please.
Thank you, Matt. Thank you for agreeing to do this fantastic collab. When I heard about the amazing work Rhiannon was doing, I needed to get her on our podcast and to have a wise solicitor like yourself, Matt, available to answer all the legal questions that I haven't got a clue about. I thought it was an opportunity we couldn't miss. So it all started because I read Rhiannon's book, Planning with Love, which is behind her on the screen, and I've got my copy here. So I am a chartered financial planner and resolution accredited divorce specialist. I've been doing this work for a whole long time now, and I work with couples and individuals who are splitting up to help them to work on their financial settlement. I think that's probably about it for today. That'll do. That'll do for my introduction.
That'll more than do. Sorry, I'm still feeling slightly taken aback at the description of me as being a wise solicitor. I mean, obviously you were aiming to get Lisa co-host this with you, but she's too busy and too important to turn up today, so you get the second choice. Rhiannon, welcome to the podcast. Could you just tell us a bit about yourself then, please?
Thank you so much for having me. Thank you for the invite. I really appreciate it. So my name is Rhiannon Gogh, and I'm a chartered financial planner, a fellow of the Personal Finance Society. I'm the founder of SENDA, which is the UK Alliance of Special Educational Needs and Disability Advisors. And I'm also the director of my own SEND planning firm, PlanIt Future Financial.
Well, thank you very much. So we're going to talk all things divorce and SEND today. So, let's just start with the absolute basics. I'm sure most people listening to this will know. But when we're talking about SEND, what are we talking about? What does that mean? What's the sort of the range in terms of conditions and the way that it can affect children?
So SEND, so Special Educational Needs and Disability, there are some interesting statistics that usually leave an audience staggered. So I will start with those and then I'll sort of broaden it out from there. So looking at disability first, 11% of children have some kind of disability, and that's according to UK disability stats. That figure has doubled over the last decade. So that is quite staggering in the number in increases of those with disabilities in children, so 0 to 18. So that's disability. Special educational needs. So when we say SEND, or special educational needs, it's describing some kind of additional support that they will need in their educational setting. And that percentage in the UK is near 20%. So 20%, 1 in 5 children have a special educational need. The biggest prevalence, or the largest area of prevalence in both of those areas actually, is around social communication. So as far as diagnoses are concerned, it is a confirmed diagnosis in autism. Usually that is the prevalent condition if you're looking at conditions within those numbers.
Okay, so maybe let's kind of start with, before we move on to the impact that divorce has on children with SEND, what are, in any kind of family unit, whether separated, whether still together, whether divorcing, what are the core challenges that families face?
Well, there are probably 5 key challenges that I've identified, and that's through research over the last 10 years and presenting to families. So I present at least once a week to families. Last week was Derby. This week it will be Somerset. So I go out and I'll present virtually or in person to families of children like mine. So my son has autism. He's 15 and he's pre-verbal. And there are 5 key challenges that I would categorize from, I would say, caring. So you might look at the caring responsibilities that I have within the family and how they'll continue. So the unique part of what a parent carer does, if you sort of look at that versus someone that cares for another relative, is I'll be lifelong caring for my son, and I'll probably die before he does. So the person that I'm caring for will outlive me. And that's absolutely terrifying. So that's a really unique concern for parent carers. There are financial resilience concerns. So it's really expensive to bring up a disabled child, generally accepted to be 3 times as much to bring up a disabled child as a non-disabled child. And my earnings are impacted by the level of care that I have to provide. So my son was up last night. He can't sleep on his own. So one of us will always have to stay with him overnight. And that means that, amongst other things, it's difficult to get to work in the morning. And it's difficult to hold down a full-time job. So we've got caring issues. We've got financial resilience issues. What I'm trying to do in my financial planning is also provide for him. So it's likely that he wouldn't be able to work in the future. So many parents like me are thinking, oh my gosh, if this young chap can't work, then how can we make plans now to make sure he's provided for in the future? So I've picked out the main challenges there, Matt. I hope that gives you a picture.
Yeah, that's really, really helpful and illuminating. And I think that, people who maybe don't have personal experience of caring for or knowing someone who has a disability such as your son, you hear that and you think, oh goodness, it's always wider than you think. I think it's the reaction. You kind of think, oh, it must be quite hard, but then you hear about the impact and you don't think about the day-to-day, the exhaustion and things, and that long-term thing. And it's really, you said it quite matter-of-factly, and I'm sure that you don't really feel that way, but the thought of, outliving your child kind of outliving you when you're their carer is a pretty scary thing. Tamsin, just I guess bring you in at this point, Rhiannon talked about some of the financial considerations there. When you're doing your work with clients, dealing with finances and financial planning, is this something that comes up often? How do you go about tackling these kind of very long-term care issues when you've got children who might live, a great many years? How do you factor that into your work?
Yeah, absolutely. It's coming up more and more. And I think although the statistics that Rhiannon just quoted floored me a bit, because that's 1 in 10 or 1 in 5 and then 1 in 5 kids. I mean, that's not then surprising that it comes up in my work quite a lot. More and more I'm meeting families who have children who are impacted like this. And I think one of the biggest issues is that families don't know what they're going to need in the future. So it's really difficult. Look, none of us know what's going to happen in our future, but we can at least have our best guess. But best guessing whether your child is going to be able to live independently, whether they're going to be able to be housed in supported housing, or whether you're going to need to provide some sort of accommodation for them. All of these things are massive. If you've got to buy a house for your child, it's a big enough consideration for the majority of us who don't have certain children, thinking about paying a deposit for our children to help them get on the housing ladder, but actually considering buying a house for them in the future. We're talking about a whole different ballgame. So there are massive considerations. And then obviously there's, as Rhiannon talked about, there are considerations post the people that we're planning for's lives. So they want to make sure that their children can be looked after and cared for and have financial stability when they're not here anymore. And I think that's one of the biggest things that SEND families are concerned about. And it's certainly one of the things that Rhiannon covers very eloquently in her book about thinking about those considerations. And then if you chuck divorce into the mix, we're in a whole other ball game.
Yeah, aren't we just? Well, before we move on to that particular ball game, I wonder if, and I know this is an enormous area full of great complexities, but for anyone who's listening, who's, maybe perhaps someone's only recently had a diagnosis for SEND in their child, maybe listen to this and starting to think about these longer term things. Rhiannon, are there any kind of, and Tamsin, any kind of quick wins, easy things, easy-ish things? Easy's relative, but any things that someone in that position might look at doing when they're starting to consider their financial future?
So I think the biggest area is really around estate planning. So when we're thinking about what happens when I'm no longer here, the biggest win that a parent can undertake is to think about a specialist trust sitting within their will. So the step back from that is just to affirm that, this shocked me too, that many parents of children like Tristan, my son, don't understand that when they pass away, if you name your son in your will, if the person doesn't have mental capacity, it doesn't automatically happen that they receive their inheritance. So I was really shocked to learn that. And many parents that I talk to when I travel around schools nationally don't understand that. And then to follow on from that, they don't understand how to protect their young person against financial vulnerability and how to make sure that the valuable means-tested care, support, or benefits that they have in place is also not jeopardized by an inheritance. And the key to all of that is by setting up a will with a specialist trust within it. So that is a wonderful and selfless place to start.
Yeah.
That's really useful. Tamsin, anything that you'd add on there in terms of the early first steps? See, you were nodding away with that, so presumably agree with everything that Rhiannon's just said.
Yeah, absolutely. And that really shocked me learning that fact. And the other thing, and I'm sure we'll come on to it, is about child trust funds. And I know this is something that Rhiannon's really passionate about letting people know about, that if you've got a child trust fund for your child and they fit into the SEND category, that they can't receive their child trust fund. And I was like, well, of course they can't, but what? How do you put that right? Because to an extent, if you've not made provisions in your will, there is potentially things you can do about it, but child trust funds are a horrendous thought. But in terms of quick wins, I think, and it's probably not a quick win, but certainly thinking about who you want to have guardianship over your child if anything happens to you, because, we're all the same. None of us know what's going to happen to us. We don't know how long we're going to be here. And we hope we're going to be here for a very long time. And most planners assume that our clients are going to be here till they're 100, but you don't know what's around the corner. And if you've got a SEND child who is going to need someone to have guardianship for the rest of their lives, finding that right person early on is really important.
Okay, so there's a couple of really helpful things, big topics to look at, but helpful things for anyone who's going through this process. So let's move on and sort of talk about why we're here today, I guess. How does this all add in as an extra layer of complexities when someone's looking at divorce? So Rhiannon, let's start with you. When you're speaking to people, speaking to parents, I mean, obviously the stress involved, life stressful, parenting stressful, the extra layers of stress, like you said, talking about sleepless nights and things that go on for years and years and years, not just in the early years of a child's life, that's going to put a strain on a lot of marriages. What do you see in terms of, people deciding to separate and divorce? Is that something you see a lot of in the sort of SEND community?
I do, but I do see it a lot. And there is an extra element of stress, I think, when you have an autistic child, but it saddens me because it's such a team sport bringing up a disabled child, and say that in the wrong way. But a perfect example would be my husband. I knew I was coming on this podcast today, so he says, right, well, I'll have Tristan last night so that you don't have to get up in the middle of the night and walk around and pull the lights back off and such. And we plan very much like that as a team. So whilst I do see it's very hard, and that caring for somebody adds an extra dynamic and an extra complication. On the plus side, I do work with divorced parents who very much still want to plan together because they're still planning the future of the same child. And it's a child that is not going to flee the nest at 18 or 21. It's a child that, I say with my husband, it could be a retirement for 3, not a retirement for 2. We'll have Tristan with us. So that there isn't really, in some cases, the option not to collaborate with planning because the caring bit doesn't really go away just because the divorce happens, if that makes sense.
Yeah, no, I've certainly seen that on the cases that I've been involved with. It is that, I'd say sweeping generalisation, but the level of collaboration has to be higher, should be higher. That's not exclusive. I've certainly had a couple of cases where there hasn't been collaboration, and then that makes the normal complexities of co-parenting even harder. So, perhaps what we should talk about is there's a couple of different areas. I'll do a very little bit of law, keep that to a minimum. But when you're looking at a separation with children, obviously you've got the two areas, the actual provision for who the children spends time with, and you've got the sort of financial element. So How does SEND play into that? If the courts got to get involved, if parents can't agree, firstly, if parents can agree about their arrangements for their children, then generally that's fine, and the court doesn't want to be involved. If you get to the point where you need some intervention, then the court has got to consider the factors in Section 1 of the Children Act, which includes the physical, emotional, and educational needs of the child. So these additional needs are really important, and the court will absolutely consider that. Obviously, continuity and certainty and routine can be a bigger thing. It's a big thing for most kids, but it can be a much bigger thing for a child with SEND. So, that's something that the court's going to try and weigh in terms of the time that the child's going to spend. But there's still the presumption is that both parents will be involved in the child's life unless there's a very good welfare reason not to. So that's just very briefly in terms of timing. But what we're going to, in time that children can spend with their parents, what we'll obviously focus today on a bit more is the finances. So how does that play in? Well, there's divorce and there's separations in an unmarried couple. We'll talk about both a little bit. But in terms of divorce, again, the main statute is the Matrimonial Causes Act. And the first consideration of the court is the welfare of any minor child. So that's the first thing that the court's got to think about, is the welfare of any minor child. It's also got to consider the responsibilities that each party has in or continue to have as part of their marriage for the foreseeable future. So that can include, yes, a child, but a grown-up child, the obligations and the responsibilities of caring beyond them turning 18. Also include, what that impact has on people's ability to earn. So we'll come on to this in a minute, I think. That's a big factor. If you're unmarried, you can rely on Schedule 1 of the Children Act, which has got some slightly different provisions. But again, it's similar in that the court wants to look at the physical, educational, emotional needs, any physical or mental disability of the child, and the manner in which the child was being or expected to be educated or trained. So maybe the schooling is different. There's additional schooling provisions. So that's a really quick run through some of the statutory considerations, but let's put these into practice. So Tamsin, could you talk about some of the financial challenges that become particularly acute on divorce?
Yeah, absolutely. So I'm working with a number of families who have SEND children, and sadly, they're not in a position that the lovely families that Rhiannon's talked about and that you've talked about, Matt, are in, where there's very much a collaboration, where they want to do things together. Unfortunately, the families that I'm working with are in a position where it's very much on the parent that I'm working with, and they're the one that's unable to work due to caring responsibilities. They don't see their children in a position where they're able to work. In these cases, they're either adult children or very nearly adult children, so 16, 17 years old. But with these, we don't know what they're going to be entitled to. We don't know what they're going to need because the parents have never been in this position before and they're not experienced in what the needs are. So, they're looking at housing not only themselves, but their children for the remainder of their lives. So that's a huge consideration, because when we're looking at, that's their starting point when we're looking at divorce and finances. Where are the children going to live? Where are the parents going to live? And we're obviously looking at housing at both parties. And this is probably one fear that I'm going to throw you back to you, Matt, because we look at children's housing, we look at housing the parents, but quite often actually moving a child out of areas. So let's say the area is not affordable for the parents to both have houses in. Moving the child out of area, out of their supportive community, out of the area that they know, even often out of the property they know, will cause immense distress. How does the law deal with that, Matt?
I think it's really tricky. I think that the problem in this area from a sort of financial perspective is that you have factors moving in different directions that are not compatible. And the factors being, your housing needs are probably higher and more expensive, but your income's lower, so your mortgage capacity is lower, so you need more capital. And that doesn't create more money. It doesn't create, there are extra issues, but it doesn't create more money to meet those problems. So the court has got to have a view as to what's best for the child. Sometimes a movement out the area might just be unavoidable, but there are other things that can be done. So sometimes what the court can do is make what's called a measure order. Now, these used to be pretty popular and are now far less so in general, but a measure order, named after the case of Mr. and Mrs. Mesher, is basically an order which says that one party, who is the primary care of the children, can stay in the family home until the children turn 18, at which point the property is then sold. And it's where there's not the ability for the parties to both rehouse and for there to be suitable accommodation for the children. They're not that popular anymore because it tends to involve the non-remaining party being locked out from receiving their share of the asset for potentially a prolonged period of time. But they are orders that still happen, or deferred orders for sale, if not, it doesn't have to be on 18, but to give a few more years. That is something that can be applied. The flip side to that is that the measure order was sort of done on the assumption that children leave home at 18, which back in the 90s when that case was decided was a thing, and now isn't really a thing, and certainly isn't a thing if you've got an SEND child. But those are options. You might look to maintain that continuity for a longer period. I mean, Rhiannon, is that something that you potentially see when you're doing your financial planning with people? You might say, well, let's stay in the family home a bit longer than might otherwise be the case just to provide that continuity for the child?
Yes, but I think you've got to bear in mind the siblings, and planning with the family home is very complex, because with some SEND families, they will know very clearly that they would want, for example, with me, I'd want my autistic son to be able to stay in this house. But then it conjures up the problem of, okay, so what happens to the inheritance of his siblings? So if if my family home is the bulk of my estate, and I'm leaving that to one son, how does the other son feel about that? And how do I as a parent feel about that? So yes, planning with the family home, as you said, but there are extra complications when you're looking at making provision for siblings as well, I think.
Yeah, that's certainly a complicating factor, both siblings and the sort of non-resident parent, if we work on the assumption that maybe there's going to be a more of a primary carer type model, even where there's collaboration. I think that's possibly more common. What that also leads to from a legal perspective is, we talked about reduced income for people. That gives extra scope for potentially spousal maintenance claims. So income's a really tricky point. The ability for a carer to maximise their income is pretty limited. They may be able to get some sort of, state support in terms of benefits. So, I mean, Rhiannon, what sort of help is out there for people in terms of benefits? We're looking at carers allowance. What else have we got?
What I would suggest is benefits are notoriously complex, especially universal credit. It's very much on a case-by-case basis. So I always suggest that parents go to some independent benefit help, and that could be something like entitled to or turn to us.
Yeah.
And just make sure they're getting what they're entitled to. The two big things they tend to miss out on are council tax reductions. That's a huge thing. And also carers allowance, because the thresholds for carers allowance have now changed. So you can earn more and still receive carers allowance. And that only changed in April. So that hasn't quite sunk in yet.
Okay. So that's really useful. But both those websites are incredibly helpful when putting information together from a divorce perspective, because we would look at it and say, okay, what's your earning capacity going to be going forward? What are you entitled to? Because some of the benefits you may not be entitled to while you're living together under the same roof. And then perhaps, if one party was to move out at the end following a divorce, the entitlement might change. So it's really important to look at that and really try and maximise that level of income. Because if you're looking at a situation where maybe the family home's being retained, so one party moves out the family home, has to then house themselves, their ability to pay spousal maintenance on top of any child maintenance is really tricky. It's really imperiled. Tamsin, any other sort of things that you look at with your clients when they're coming to you and trying to square this really difficult circle of, moving on to the next stage, not necessarily wanting to have a new property, but having to release some equity? Are there any other magic tricks that you can conjure up for them?
I wish it was down to a magic trick, because that would make it a whole lot easier. I think we all meet people who we'd really like to create some magic for and just be able to solve things really easily. But like you said, we've got housing to consider, we've got probably low income or the inability to earn any income. And then we've got actually considering the child's needs now, but also in the future and into, through our clients' retirements. It's a very difficult puzzle to solve. And I think you'll probably be able to talk on this, Matt, a bit more, but we look at, is it possible to provide some assets? There might not be the possibility of spousal maintenance from income for the non-resident spouse to be able to afford. Couldn't we separate the capital assets differently to maybe square that circle? How does a court deal with that?
Yeah, I mean, the starting point for division of assets is add up and divide by 2 of matrimonial assets or anything that's a product of the marriage. And then you depart from equality for a number of reasons. So the most common to meet needs. And in cases like this, your needs for capital are likely to be heightened by virtue of the fact your income is, let's assume that the resident carer's income is going to be lower. So probably means you need more equity to buy a property, or you need a slush fund to support you, or to use equity from a house sale. Perhaps you have to go into rented and you have to use it to pay the rent. So perhaps, or alternatively, you can be looking at a spousal maintenance order, but instead you capitalise that order. So instead of someone paying X amount per month in spousal maintenance, you can say, well, instead of paying £1,000, I'm going to do easy maths, £1,000 a month for 3 years. Instead of you pay that every month, you say, well, £1,000 a month for 3 years is £36,000. You pay that as an extra sum to capitalise a maintenance claim. So there are various ways of doing it. I think that, so certainly, that would probably be my expectation, that there's more likely to be a departure from equality unless you're dealing with a sort of sharing case where there are a lot of assets to go around. And most cases aren't like that. I think what is tricky, and we were talking about it a little bit before about needs. So needs is this hugely important concept. And commonly when we're looking at needs on divorce, it's needs for housing, needs for income, needs for pension. Fairly foreseeable, fairly predictable. But with cases such as these, things seem to me to be far less predictable, and we have to look at needs over a longer term rather than the initial 2-3 years. We have to start. Family lawyers love saying this. Family lawyers love saying we don't crystal ball gaze. I think in these cases we kind of have to crystal ball gaze. So how do you approach that, Rhiannon? The need to look in the short, medium, and long term.
That's very difficult, to be honest. When you're talking to parents, some parents struggle to think beyond Friday, quite frankly, let alone into the long-term future. My advice when I'm talking to them, first of all, I don't shy away from asking questions about that. Many of the families that I work with want to talk about their children, and they want to spend time talking optimistically about the future of their child as well. So what I will often ask is, I will ask around long-term vision about whether they're likely to live independently, whether they're likely to earn and work, what the vision is for the long-term future. And I'll usually preface the question by saying, I know it's hard, but I know it's difficult, but can you imagine them living in? I know it's difficult, but can you imagine them working? So I will always ask the question. And then the second thing I would say is, sometimes I will speak to parents and they'll say, Rhiannon, I just don't know, is the honest answer. I really have no idea. And in that scenario, I would say, which is probably not the answer you want to hear, Matt, is to plan flexibly. So to build in.
We hate flexible. Come on, this is speaking to a lawyer here. We deal with certainty and nothing else.
Well, I don't. So I will build in the ability for one trust to change to another. Yeah. The ability to add in future trustees, the ability to have a backup guardian, all of those exciting flexibilities. I'm sorry, that's how I tend to plan.
No, it's very sensible. It slightly gives me a migraine at the thought, because we like things that fit on one sheet of paper and make things nice and clear. But life doesn't work like that. In the easiest in quotes, divorce, life doesn't work like that. So obviously, in cases such as this, the flexibility is really important. Tamsin, can you kind of recognise that need for flexibility with your clients?
Yes, but I also spend my life working with lawyers who need certainty.
Blame the lawyers. We're awful people.
Absolutely dreadful people. I guess when we're working in divorce, we need we need a little bit more certainty. We obviously want to give flexibility to the family, but with a little bit more certainty. So we want to be thinking about what are the needs likely to be, bigger needs likely to be for the SEND children. How are we going to deal with those bigger needs with both parents? Can we put anything into place if something changes that we can't currently anticipate? So is there a possibility of, well, can we agree up front that if there's a big need, financial need in the future, that we pay for that between us, that we share bigger costs, how are we going to work out who pays what for these bigger things? Because it can't all fall onto the resident spouse. If there's a big change need to be made to the property, for example, because of needs of the child, that can't all fall onto the resident spouse. So how are we going to deal with those in the future? And if we can think about those sort of things that might be required in the future, we might be able to think flexibly enough for the family's planning, but sort of precise enough for the lawyers to be able to put something down in paper and in order to keep them happy as well.
Yeah, no, I think that's all very sensible stuff. So for anyone listening to this and thinking, oh, that's giving me some ideas or stuff that I hadn't thought about, need to think about, that I guess, what's the, maybe thinking, how do I go ahead? I mean, I'm going to cut to the chase and say the answer is to speak to you two. So what's your role? When do you, maybe explain a bit about how you work with parents and how you work with families, and what does it actually look like being a financial planner working with people in this situation?
So many parents will come to me before they see their solicitor, and they'll come to me because they don't really understand the way forward. They might have had a conversation amongst other parents. They might have an inkling they have to do something, but they're not sure what they have to do. So they will come to me almost like a coordinator. So I'll be able to talk to them about the protections that we're looking to put in place. That's estate planning, providing care funding for the future, and ultimately forming a special needs plan. So that is estate planning, savings planning, care planning, and then not forgetting the parents planning too. So planning for the parents. It's almost like a buy one, get one free when you're a special needs planner, because you have an extra person to plan for. So that's the role that I'll play. So they'll come to me, we'll talk about the different options, and then we'll go together. Usually I will refer to a specialist solicitor to put in place specialist trusts. And then I will, once that's done, I will start care funding and putting together a picture of that child's life, and then slotting together the funding that sits behind that, making sure that grants and benefits are applied for and secured, and making sure that all the planning that the parents have in place is safely accessible, and that it doesn't impact that future means-tested care that's so incredibly important. So that is my role. And then I work within Sender. So in answer to your question, how does anybody get involved in this, or how do they find more information? Well, Sender is a collaboration between financial planners and legal advisors and charities. So I work with the MenCap Trust Co. I'll be working with specialist EHCP solicitors and wills and trust solicitors, all as a team. And that's when special needs planning is really the best, when it's a team and we're kind of going back and forth between ourselves and making sure we've got the right plan in place.
Fabulous. And Tamsin, anything that you can add to that, and how what is in it for parents to start working with a financial planner?
And if we tip in divorce into the midst of all that Rhiannon's just said, we complicate it even more. With divorce, it's always vitally important to have a divorce team. We've talked about this on the podcast before, but you definitely need a financial expert. You need a legal expert. You preferably need an emotional support expert as well, so a therapist, a divorce coach, somebody who can give you that emotional support so that you're not spending your hard-earned cash crying on me or Matt because we're not qualified to deal with you with those things, as well as somebody else might be. So we're adding the divorce into the mix. Quite often people come to me before they've seen the solicitor. Quite often they come via their solicitor, but we're going to help you work out the money bit. And we're going to hold your hand through the process. And there will be, if you are a SEND family, there will be other things that you need to have in place and that you need to do. And that's where we'd refer to Rhiannon if we need to. but also would work on working with wills and trust solicitors to make sure everything's sorted out, so that once you come out the other side, everything's sorted. But we've just thrown so much stuff at you, and to deal with all of those things. I mean, most people suffer overwhelm when they're going through divorce as it is and feel like it's a full-time job. So we're not going to do all this. Rome wasn't built in a day. It's very slow, very careful, at your pace. No pressure, no rush. You don't have to, just because your relationship's broken down today, it doesn't all need to be done tomorrow. It needs to be at your pace.
Yeah, I think that's really helpful advice. It can seem so overwhelming, and particularly if you've got the extra complexities of what can be a very difficult home life and your concerns about your child and trying to manage their education and all of those things that come with it, on top of all the normal stresses. It's a huge amount. But well, that's been enormously helpful. What we, as you know, Tamsin, but what we always like to do on these podcasts is leave people with a little top tip at the end of, for a little takeaway message. So I wonder if you could each give me your top tip for anyone who is an SEND family going through a divorce, whether just about to start or partway through the process. What's each of your kind of top tip as how to deal with that?
So my top tip is really just to be aware of the foreseeable harms that exist for SEND families that don't exist for other families. And there are two big ones, so I'm going to give you a double top tip because that's both really important.
Buy one, get one free.
Buy one, get one free.
There we go.
So if there is inheritance tax, estate planning, wills and trusts, so doing nothing as an SEND parent in the area of estate planning is rarely a good thing. So we always advise seeing a specialist wills and trust solicitor to get the estate planning ticked and safe. But on the other side, so there's like two bookends of special needs planning, and that is one side, which is estate planning. The other, as Tamsin rightly said, please be careful when you're saving for a young person with SEND. Quite often families don't realise that when the child gets to 18, if they don't have mental capacity, they will not be able to access their savings. They may be very vulnerable if they could access it, and it will likely impact their means-tested benefits, care or support when they get to that age. Parents are very often unaware of that.
Perfect.
Tamsin?
I'm going to do buy one, get one free as well.
Love it.
So my first tip is that dealing with SEND children is not just a parental issue. It's an issue for the entire family. So if you've got parents, brothers, sisters, uncles, aunties who are thinking of leaving money to your child, the exact same thing applies to inheritances from them as it did as with inheritances from the parents. So speak to anybody you think might be likely to be leaving money to your child and explain to them about the trust that you've set up or the work that you're doing to set trusts up with specialists and make sure that they're going to be able to access those inheritances as well and that those are set up properly. So that's my first top tip. My second one is please buy Rhiannon's book because it's brilliant. I've sent it out to at least 6 clients already. It will be on the list to go to anybody that I ever meet who's got a SEND child in their family, whether it's immediate or their friendship group or whatever. It's flipping brilliant. Thank you.
One last chance for a plug for the book, Rhiannon. So the book is called, and where can people get it? Available at all good bookshops? Let's do a proper plug.
All good bookshops, yeah. It's Planning with Love by Rhiannon Gogh. All good bookshops.
Fabulous. Well, thank you both. That was really illuminating and hopefully really useful for people. So that's it for this podcast. Thanks so much for listening. If you'd like to find out more about Stowe Talks, visit stowetalks.co.uk and please like, rate, share and review this podcast where you can. If you'd like more information on the brilliant work that Tamsin does, head to smartdivorce.co.uk for all the brilliant stuff on her website and her Smart Divorce podcast. And to find out more about Rhiannon's work, head to PlanIt Future. That's PLANIT Future, not planet like we live on it. planitfuture.co.uk. And there's also sender, senda.org.uk. But thanks again for listening, and we look forward to seeing you soon here on Stowe Talks. So thanks for joining us on this special collaborative episode.